At our firm, Jaroslawicz Jaros, we have handled many construction cases over the years. In fact, we have handled many appeals to the Appellate Division and to the highest court of New York, the Court of Appeals, in establishing and defining what the law is when it comes to construction workers. There's a special body of law that pertains just to the protection of construction workers who are injured on the job. This is called the labor law of the state of New York. The two most common sections that apply are Labor Law 240 and Labor Law 241-6. Labor Law 240 applies to a construction worker who falls from a height, whether from a ladder or a scaffold, through a hole in the floor, or some other reason. The law provides protection for that worker so that if he's injured due to a fall, either an object falling from a height or the worker falling from a height, that worker is entitled to their full compensation, regardless of what that construction worker may or may not have done to contribute to the accident. Under 241-6, the responsibility of the construction worker for his injury is taken into account, so that if you're injured on debris while you're walking by a job or by a defective tool or product, then the question is, to what degree were you at fault, but you're still entitled to some compensation. The theory behind the labor law, whether 200, 240, 241-6, is that the landlord, the owner of the building, the general contractor, and every subcontractor has to do everything possible to make the job safe for the construction worker who's doing a very dangerous job. And if they don't make it perfectly safe, the worker who's injured is entitled to be compensated.